Good morning. It's Benjamin Sanchez. I'm here in Houston. It's a special Sunday edition of Coffee with Law. Today, I have a protein smoothie, not coffee. I wanted to tell you a quick story today rather than teach you about a particular point of law, and it has to do with evictions, which we've covered this past week. And it led to what some lawyers consider to be the greatest compliment a lawyer can receive. And it's this. A few years ago, I represented a tenant in a home whose owner had been foreclosed upon. So this was a woman who lived in a home who was renting from an owner of the home, and that owner was foreclosed upon by the bank. So the bank wanted to evict the tenant. And in Texas, as I described earlier, you have to have a 30-day notice in order to evict someone after a foreclosure who's a true tenant, assuming that tenant is all caught up with their rental payments. Well, the bank sent out a 30-day notice. However, the bank sued for eviction prior to the end of the 30 days. Now, you would think that that would be an open and shut case in court. Unfortunately, a lot of justices of the peace see so many evictions that they end up just rubber stamping those evictions. And in this particular case, the justice of the peace ended up granting the eviction despite the bad notice, despite the lawsuit being filed before the notice period was up. So we had to appeal to county court. Now, when we appealed to county court, we there was a question about whether or not the bank had truly done the foreclosure properly. The prior owner ended up suing the bank for wrongful foreclosure, which basically stalled the eviction. Now, in Texas, an eviction is totally separate from a lawsuit in district court regarding the title of the property. So, in most cases, a wrongful foreclosure lawsuit will not stop an eviction. However, we did ask the county court judge in the eviction appeal to stay the eviction proceedings because if the owner won the wrongful foreclosure lawsuit, then the owner should be able to keep the house and the tenant should be able to stay into the house. So that wrongful foreclosure lawsuit ended up taking a while, taking us a few years actually. At some point, about a year and a half in to the wrongful foreclosure suit, the bank attorney went to the eviction court and said, "Judge, we know that this lawsuit over in district court is going on. However, we don't think that the tenant should stay in the property for free. So we want the tenant to pay rent to us while the district court lawsuit is going on." What I told the judge was that, "Judge, the wrongful foreclosure lawsuit may actually be won by the owner, and thus the bank will get a windfall of getting rental payments that they didn't deserve." So as a compromise, what the eviction judge did is said, "I will order rental payments, but they must be put into the registry of the court. And then whoever wins this eviction lawsuit will get those funds at the end of the lawsuit." The eviction payments, the rental payments were $1,000 a month. So the wrongful foreclosure lawsuit keeps going. There's an appeal. Eventually, the owner loses in the wrongful foreclosure lawsuit. So when that case is done, we go back to the eviction court, and the county court judge starts the eviction proceeding again, and we eventually go to trial. At the time of trial, by this time, there's $28,000 sitting in the court registry because there were 28 months of $1,000 payments made by the tenant while while the wrongful foreclosure lawsuit was going on. Now, remember what I told you earlier, the bank's attorneys sued for eviction prior to the 30 days. And something that should have been easy for the bank's attorney to correct. Instead, they just relied on their prior notice and the lawsuit. And I had told them back in JP court 4 years prior what their mistake was. And the bank's attorney dug in their heels and said, no, we're going to go forward on what we did as being proper. Well, the county court, being an attorney, because all county court judges have to be attorneys, and knowing the law, sided with our side, sided with my side and my client, the tenant side, and dismissed the eviction by the bank after 4 years. And the $28,000 in that court registry came back to the tenant. Now, you may think that that's, an unnecessary windfall for the tenant, but as the county court judge explained to the bank's attorney that day, you knew from the very beginning when Mr. Sanchez filed his answer back in the JP court over 4 years ago that all you had to do was dismiss that lawsuit and do it properly. It was you that chose to stick to the lawsuit, and so therefore you now reap the consequences of your bad action. After that, the bank decided that they didn't want to deal with facing me in an eviction anymore on behalf of my clients. So the bank sold the property. The bank sold the property to a new owner over the internet. Needless to say, the new owner hired some attorneys to try to do evictions and didn't do it properly. This story that I'm telling you is actually the basis of an hour-long continuing legal education seminar that I give to attorneys. So I'm not going to tell you the entire thing, but I will say this. Suffice it to say that the new owner, after the bank, ended up suing for eviction 6 different times using 3 sets of attorneys, and still was losing the evictions because they just did not have their act together in terms of exactly how to do it. And this is why I told you yesterday why it's important to get an attorney, because between the bank's failures and the new owner's attorney's failures, I was able to keep that tenant in the home for about 8 years. Eventually, we settled because it had already been 8 years and there was a district court case going on and the eviction case going on. And so eventually we settled, but the client tenant was able to move from the home, not having paid any rent. I mean, she did pay rent when she was ordered to, but then that was given back to her. So she was able to leave, not paying any rent, not paying any attorney's fees, and had all that time to get her life together to be able to move. And so I told you at the beginning that led to what some people think is the greatest compliment a lawyer can receive, and that's this. That case ended a few years ago. A few months ago, I received a call from the last opposing counsel that I had in that case. And that opposing counsel was referring me a client. And that opposing counsel specifically told me that he remembered how difficult I was as an opposing counsel, that I was able to keep my clients in the home, despite what he thought was going to be something that should have been fairly easy. And because of that, he had a client who really needed an attorney, or he had a referral for a client who really needed an attorney that was going to know the law and be able to potentially knock holes in the other side's arguments in eviction and keep the clients in there because they were not ready to move. And so a referral from an opposing counsel is what some lawyers consider to be the greatest compliment a lawyer can receive. I'm not so sure about that. That is actually a great compliment. I'm not sure if it's the greatest compliment. And I think next Sunday, I will tell you another story that some consider a great compliment as well. So I hope you've enjoyed this story. I hope that sort of encapsulates why an attorney can be beneficial to you, regardless of your situation. I'm about to go for a bike ride, which is why I have this cap and my buds and my t-shirt. It's a beautiful day here in Houston, Texas. I'm going to take a bike ride. I hope all of y'all have a great day. And we will start tomorrow talking about debt defense and the issues that come up when a creditor sues someone for debt. Have a great day, guys. Bye-bye.